So, my dear friends, we are beginning with the new essential, next essential of Contract Act, which is called as consent. So, whenever we talk about the contract, so we are aware of that contract comprises of the promise by one party to another to do or not to do something, and with a view to obtain assent of that other. And when other party agrees to the same, then in that particular situation, the party has agreed and they are going to perform as per the terms of the contract. Now, if we say the contract, so we have discussed that agreement enforceable by law is a contract, and we have discussed that this requires to be enforceable by law requires all the essentials given under Section 10. So we have already discussed in detail about the meaning of agreement, intention to have legal relationship, rules regarding valid offer, valid acceptance, rules regarding lawful consideration, and also where if the consideration is not there, then how it can be enforceable by law, and the capacity of parties. Now the next essential of the Contract Act says that their party should have given their consent. There should be the free choice to enter into the contract. So we have discussed in case of offer and acceptance as well, that when a person makes an offer, then acceptance should be absolute and unqualified. It means that acceptor have the option, have the right either to accept or to reject. So अगर वो accept कर लेता है और promise हो जाता है, and keeping in mind other all things are there, it will become a contract. और अगर वो reject कर देता है, so it will remain the promise, and it is not enforceable by law because it does not turn in the form of the contract. Now, in along with this, we have also discussed that there should be consensus at either. So we have discussed that there should be parties' mind should be in full and final agreement at the time of formation of the contract. So they are talking about the same subject matter. They are understanding the terms and condition in the same sense. They are, on the same page. So if they are on the different aspects of the things, be it the ownership, be it the quality of the goods, be it the price or any other thing, तो अगर वो सेम चीज पे अग्री अपॉन नहीं कर रहे, और इफ देयर इज नो कंसेंसस एट idem or both the parties are at mistake, then in that particular case it will not give rise to contract. तो वो कॉन्ट्रैक्ट नहीं बनेगा. तो हमने पहले डिस्कस किया that if there is no consensus at idem, there is no contract. So now we talk about free choice. So acceptor have the choice. Terms and condition offerer ने रेज करनी है, लेकिन जो एक्सेप्ट करेगा उसके पास पूरी चॉइस है कि वो उन टर्म्स एंड कंडीशंस को एज इट इज लेके एक्सेप्ट करता है या नहीं करता. और अगर उसको वो नेगोशिएट करता है, तो इन दैट केस ओरिजिनल ऑफर कम्स टू एन एंड. सो ऑल दीज थिंग्स वी हैव ऑलरेडी डिस्कस इन डिटेल. सो नाउ व्हेन वी टॉक अबाउट द कॉन्ट्रैक्ट, सो वी से एवरी कॉन्ट्रैक्ट must have been entered into by the consent of the party. And when we are talking about the consent, we are talking about the free consent. तो consent तो हो सकती है, but there can be certain kind of compulsion or pressure. So as per law, a consent of the party is said to be free if the consent is not affected by any of the following. One, coercion. This is to be discussed under section 15. Undue influence. Section 16. Then fraud, misrepresentation, and mistake. Section 17, Section 18, and Section 20. Right? So now if we say that if the consent of the party is affected by any of the following element, it is said not free. And if the consent of the party is not free, have been affected by any of these particular elements, it will not give rise to a valid contract. So what we have to discuss is that what do we understand by the coercion, under what circumstances the consent is said to be affected by coercion, और अगर coercion होता है तो उस particular situation के अंदर आपकी contract की क्या validity होगी, क्या legal position होगी. Similarly, what do we understand by undue influence, under what circumstances it is considered dominance of will is there, or under what which situation the particular circumstances are covered under fraud, where the silence amounts to fraud, where we consider that there have been misrepresentation in the contract, or where the parties were at mistake. So all these five elements we have to cover as a small five sections, and there can be an independent question on these. There can be the difference question, that what is the difference between coercion, undue influence, or fraud, misrepresentation, or in case of mistake, bilateral mistake, or unilateral mistake, or mistake of law, or mistake of fact. So, or there can be a simple question that under what circumstances consent of the parties to be set to be free, or where silence amounts to fraud. तो ये छोटे छोटे portions जो हैं, this can be asked as a question in your exam, or some case study or some example can be given, and you may be asked to explain the example with the help of the provisions of the law. So I hope up till now it is clear what do we understand by the consent and when it is said not to be free.
Yes,
Yes,
ma'am.
can we move further? Let me share the presentation. If we say free consent, so if you see free consent, so it is said that section 13 says that two or more person are said to consent when they agree upon something in the same sense. So यहाँ पे आपका consensus वाला point आ गया कि जब भी promise होता है and two parties are entering into the promise and have the intention to have legal obligation, are willing to perform, legality of object भी है, और ऑफर एक्सेप्टेंस भी है, कंसिडरेशन भी है, पॉसिबिलिटी टू परफॉर्म भी है, बाकी सारे एलिमेंट्स हैं. हियर वी आर जस्ट टॉकिंग अबाउट द वन एलिमेंट दैट इज योर कंसेंट. तो जब दो या उससे ज्यादा लोग एक दूसरे के किसी चीज को करने के लिए सेम सेंस में सेम टाइम पे अग्री करते हैं, so we say that the parties are to consent. And as per law, section 14 says that consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation और mistake. So any of the element, कोई भी एक element आ जाता है तो वो consent जो है आपकी वो unfree हो जाती है. उसका लीगल इम्पैक्ट क्या होता है कि जब अग्रीमेंट में कंसेंट आपकी फ्री नहीं होती तो आपका जो कॉन्ट्रैक्ट होता है वो वॉइडेबल हो जाता है उस पार्टी की ऑप्शन पे जिसकी कंसेंट फ्री नहीं है. इफ वी टॉक अबाउट द मीनिंग ऑफ void agreement, so void agreement is voidable contract is one where the contract is enforceable by law at the option of one of the parties and not at the option of the other. So this we have already discussed in the first chapter. Voidable contract का और हमने वहां डिस्कस किया था कि voidable contract कहाँ पे होगा, जहां पे आपकी कंसेंट जो है फ्री नहीं होगी. सो नाउ वी हैव टू डिस्कस एंड लर्न कि कहाँ पे आपकी कंसेंट जो है वो फ्री नहीं है. सो नाउ वी हैव टू मूव towards the meaning of these elements. So the very first element is coercion, which is being explained in the section 15. Any idea anyone can tell about if you know anything or something about coercion? Yes? Okay. So definition हम बाद में करेंगे. Let me explain it into the simple words.
मैम
हाँ जी बेटा.
मैम कोर्जन बेसिकली मैम वो होती है मैम जैसे किसी और को इन्फ्लुएंस करना किसी काम करने को लाइक उसको थ्रेटन करना या फिर उसको फोर्स करना या फिर
Right.
उसको एट गन पॉइंट बोलना कि ये काम करना ही करना है इस कॉन्ट्रैक्ट को साइन करना ही पड़ेगा दैट इज कोर्जन.
Very good. So when we talk about coercion, coercion means a physical threat or any act which is forbidden by Indian Penal Code. So अगर कोई भी physical threat use कर रहा है or actually doing any activity which is forbidden by law. forbidden by IPC. So if he is actually doing that activity or attempt to do that activity or threatening the other party to do that activity, so this would amount coercion. For example, on a gunpoint, A says to B that you transfer your this bungalow in my name. He has transferred, this is on stamp paper, witnesses are there, it is signed and registered. So, on the face of it, it is a valid contract, but the consent of the party was not free. So, in that case, the party can go to court of law and can set aside the contract on the basis of that his consent has been affected by coercion. So, you must have seen in most of the movies this particular thing happened that on physical threat or on that those basis the other person take the advantage of the other party. So, उसमें क्या होता है when we talk about we discuss the object of the contract act, तो हमने यही object discuss किया था that the your social commitment, your social activities or your performance or your routine activities, everything depend upon it would have not been smooth if the law is not there. I had given the example in the very first class that I left my car in the parking and after that I could not find it and I don't have anybody to ask for it, or I don't have any system in the country where I can ask about my car or about my belongings. I left my home, someone else is sitting in the home, and the person is more powerful and say, sorry, this is my home. You don't have any right to enter in this house. So these kind of situations, or you can imagine the chaos, or you can imagine the circumstances which will emerge without the existence of the law. So law is here to protect the interest, to have the system in the society. So if we talk about the coercion, so even though the person has got the particular asset transferred, that's okay. But you have the court, you have the law, you have the system where you can plead for the justice. So if there is any kind of physical threat, either threat is there or doing that activity is there that forbidden by IPC, so it would amount to coercion. A says to B, I will kill your son. अब उसने kill नहीं किया, but threat तो किया, so that would amount to coercion. A has actually kidnapped B's son. अगेन दिस इज एक्टिविटीज और इसके अंदर एक चीज आपको ये ध्यान रखनी है कि इट्स नॉट दैट इट्स फॉरबिडन बाय आईपीसी तो वो कोर्जन जो है सिर्फ इंडिया में ही एप्लीकेबल होगा इफ समथिंग इज इलीगल समथिंग इज फॉरबिडन बाय लॉ सो वेदर इट हैपेंस इन आवर कंट्री और इन अनदर कंट्री a has threatened to kidnap B's son and B's son is residing in USA so he says okay अब इससे क्या फर्क पड़ेगा वो तो यूएस में है how he can be kidnapped right it's not so so any activity whether it is actually being performed or it is there is threatening to perform that particular activity it would amount to coercion next thing comes detaining or threatening to detain property of another to the prejudice whatsoever is possible. So, if you have access to some information, access to certain books of accounts, or access to certain kind of belongings to the other person, so either you are unlawful, detaining is unlawful. अगर आप lawfully किसी चीज को detain करते हो तो law doesn't oppose that. But if there is any kind of unlawful detaining or threatening to detain property of another, then it would amount to coercion, right? So let's see the definition here. That meaning of coercion, section 15 says, coercion is the committing or threatening to commit any act forbidden by the Indian Penal Code or the unlawful detaining or threatening to detain any property to the prejudice of any person whatever with the intention of causing any person to enter into an agreement. So 4 points हो गए आपके committing and threatening to commit, unlawful detaining और threatening to detain. 4 points cover हो गए प्लस उसमें इंटेंशन क्या होनी चाहिए इंटेंशन इज टू कॉज द अदर पार्टी इनटू एन एग्रीमेंट तो अगर आपने दूसरी पार्टी को अग्रीमेंट के लिए कंपेल ही नहीं किया तो उससे हमारा क्या इम्पैक्ट आएगा सो इफ वी हैव टू enter into the contract so in that case there should be that activity should have resulted into the contract, राइट? तो उसका अल्टीमेट जो ऑब्जेक्टिव है टू कैरी ऑन दीज एक्टिविटीज, इफ यू यू नो एंटर इनटू एनी एक्टिविटी बट उसका रिजल्ट कॉन्ट्रैक्ट में नहीं है, तो इंडियन कॉन्ट्रैक्ट एक्ट के रूल्स उस पर एप्लीकेबल नहीं होंगे. सो फॉर दैट थिंग either of these four activities have been engaged, or the this purpose of carrying of any of these activity is to compel the other person to enter into the contract. Now this coercion has happened. Now what is the we can say result of this, that we say it results into a voidable contract. So if consent of party is affected by coercion, then the contract is voidable at the option of party whose consent has been so affected, right? So those who have joined little late, or have not understood the concept of voidable contract, so we have to see that voidable contract is one which can be avoided, in simple words. तो voidable, otherwise हम कहते हैं contract is enforceable by law, the parties are bound to perform, they have the legal obligation. Once you have entered into a contract, you cannot take your steps back. So in this case, when we say voidable contract, तो एक तरफ तो हम कॉन्ट्रैक्ट वर्ड यूज कर रहे हैं विच इज एनफोर्सेबल बाय लॉ, एक तरफ हम यूज कर रहे हैं अवॉइडेबल वेयर कॉन्ट्रैक्ट कैन बी अवॉइडेड. तो किस सर्कमस्टांसेस में वो अवॉइड हो सकता है? जहां पे पार्टी की कंसेंट ना फ्री हो. सो इट मीन्स कि अगर वो सेट असाइड नहीं करता तो वो एनफोर्सेबल हो जाएगा, because the court of law at the face of the property papers or otherwise is not going to ask you or confirm कि आपकी consent free है कि नहीं है. On the papers there are signature, your signatures are there, witnesses are there, registered agreement है, तो no one can make out that it is not enforceable. So it is enforceable, but once you elect to set aside, you have the right to make it voidable. So you can select it not to perform within the preview of law. So within the preview of law, what you have to do is that you have to go to court of law and you have to file a case to set it aside. But वो set aside करने का right किसके पास होगा? जिसकी consent free नहीं है. The person consent of the party is affected by coercion, then the contract is voidable at the option of the party whose consent has been so affected. तो voidable contract का meaning ही यही है. Voidable contract is one which is enforceable by law at the option of one of the parties and not at the option of the others. So if you see, if you remember the definition, so you can see ki what was the definition. So you can check it if I am able to see. I think I have written it as classification. Mhm. No worries. I think I'm not able to find it right now. Otherwise, I would have shown you again the definition or rules which we have discussed. So, any query up till now?
No, ma'am.
Okay. So now let's move to the definition. So it says coercion is the committing or threatening to commit or act any act forbidden by Indian Penal Code, or unlawful detaining or threatening to detain any property to the prejudice of any other person, whatever the intention of causing any person enter into an agreement. So if you are able to remember these commas and word to word, then use the inverted commas. Otherwise, you can remove these inverted commas, and you can even write down the definition as I have written, the meaning of coercion, point number 1, 2, 3, 4, and you can explain it in the exam if you are not able to remember word to word, right? Then we say features of coercion. Now we have to understand all the 4 points we have discussed. That one is that committing or threatening to commit any act forbidden by Indian Penal Code. So in this particular case, this case law Rangana Kama versus Alvar Sethi case, in this particular case, a lady has been compelled to adopt a boy, and then only she was allowed to complete the last rites of her husband in case of his death. So this she had adopted the boy, but later on she has set aside the contract on the basis of that her consent was not free. So this has been considered as the law that this particular situation, the consent of the party was affected by coercion, and the party had the right to set aside the contract. So court has given the decision. So whenever we talk about the case law, we say that the facts of the case, then the provisions to which it is being related, and what has been the decision in the case. So these three paragraph you have to, all the, whenever you write the example or you explain certain case, so all these three aspects must have been covered in that, right? Then we say unlawful detaining or threatening to detain any property to prejudice of any other person. So either he has detained or threat to detain the property. So in this particular case, Puthya versus Karupan, the agent was having the access to the books of accounts. And these books of, because when we use the word to the prejudice of other, it means कि उसके पास उस चीज का access होना चाहिए, or either he is threatening to do that particular activity. So when the property belongs to another and you are unlawfully detaining that property to the other, it will be covered by coercion. So this particular case law can be referred here. And then the act of the threatening or coercion may proceed from the third party to the contract or stranger to it. So when we say that A has, threatened the B to kidnap his son, in that particular case, A might himself has not done that activity. He might have hired C, or he might have hired some other party. So in case of coercion, that particular act can be performed by the third party or can be performed by the stranger to contract, but that activity should be there which amounts to coercion. Is it clear? Right? Then next is that the act or threat may be directed either against a party to the contract or any other person. So when A is asking B that I will kidnap your son, or I have already kidnapped your son. So in that particular case, A has taken action against the son. Son has become the matter. सो इन दिस पर्टिकुलर केस जरूरी नहीं है कि जिसके जो पार्टीज के बीच में कॉन्ट्रैक्ट है उन्हीं के अगेंस्ट, उसी के फिजिकली उसके अगेंस्ट एक्टिविटी हो. So there can be any other person. So basically this there should be direction can be against the party to the contract or any other person. So this example clearly explains this point. Then there must be done with the intention to cause the other person to enter into contract. So if the result of that particular activity or coercion is not to enter into contract, there is some personal enmity or there is any other reason, so in that case it would not amount to coercion. Then it is immaterial whether IPC is in force or not in force at the place where coercion is employed. So it means that whether it is employed in this country or other country, so whether the Indian Penal Code is applicable or not there, but if that particular activity transaction is affected by or restricted by IPC, it would be covered in that. Then there comes the effect of coercion. So when we say section 19, 15 coercion, 16 undue influence, 17 fraud, 18 misrepresentation, 19 effect, and 20 आपका mistake का. So I think you can serially wise इस particular chapter में बहुत easy हैं sections याद करने, so you can remember. So section 19 says that if the consent of the party is caused by coercion, the contract is voidable at the option of the party whose consent has been so caused. So let me tell you very interesting thing कि जहां तक आपका undue influence, coercion, fraud और misrepresentation है, इन सब में आपका सेक्शन 19 एप्लीकेबल है। इन सब सिचुएशन में आपका कॉन्ट्रैक्ट जो है वो आपका वॉइडेबल हो जाएगा। बट इन केस ऑफ सेक्शन 20, in certain situation it is going to be valid, and in certain situation it is going to be void agreement, and in certain situation it is going to be voidable. So void agreement. So section 20 में effect change होगा, but up till section 15, 16, 17 and 18 तो वहां पे आप coercion की जहां पे आपका coercion आएगा you can use the word coercion, जहां पे undue influence आएगा वहां पे undue influence use करना, fraud or misrepresentation. So language will remain same section 19 when the consent of an agreement is caused by coercion slash undue influence slash fraud slash misrepresentation. The agreement is a contract voidable at the option of the party whose consent was so caused. Right? So what we have to discuss is the meaning of the item coercion है, undue influence है, fraud है, misrepresentation है, then उसकी applicability कि वो applicable है या नहीं है, then उसका आपका we can say effect, and effect is same in all the cases with slight changes in case of fraud or misrepresentation extension है वो हम discuss करेंगे. Then if you remember section 64 डॉक्ट्रिन ऑफ रेस्टिट्यूशन, इसलिए मैंने पहले वाली क्लासेस में ज्यादा डिटेल में एक्सप्लेन किया था बिकॉज आई नो दैट दीज थिंग्स आर गोइंग टू बी repeated or used in the coming chapters as well. So when we talk about doctrine of restitution, anyone can explain doctrine of restitution? Yes, yes beta, anyone would like to explain doctrine of restitution?
मैम याद है बट
Okay,
एग्जैक्टली
याद
ऐसे
है,
याद नहीं है।
जितना जितना समझ में आया हुआ है. आई डोंट से यू हैव टू से एज इट इज, वट एवर यू हैव अंडरस्टूड यू कैन एक्सप्लेन. डॉक्ट्रिन ऑफ रेस्टिट्यूशन सेज कि अगर किसी भी कॉन्ट्रैक्ट के अंदर आपने कोई भी बेनिफिट, मनी और एनी अदर requirement or any other interest you have received, right? So once you have received, then there should be the return of the promise. Consideration honi chahiye na, return mein aapko you need to do something, but when you are setting it aside, then in that case you do not have right to keep these benefits etc. मिलना चाहिए right, नहीं मिलना चाहिए ना. सो डॉक्ट्रिन ऑफ रेस्टिट्यूशन कहता है कि वंस यू आर सेटिंग द कॉन्ट्रैक्ट असाइड, द कॉन्ट्रैक्ट इज वॉइडेबल एंड यू आर नॉट परफॉर्मिंग इट. तो अगर एज पर जस्टिस law of justice and as per it is says that no one is allowed to enrich himself at the expense of the other, so in that case you are bound to return or restore that benefit from whom it has been received. So this is called doctrine of restitution, section 64, and it is applicable in case of voidable contracts. And we say that if a party has received money, a person to whom money has been paid or anything delivered under coercion must repay or return it. So doctrine of restitution says that if any party has received any money, interest, benefit, etc., in a particular contract, and that contract is set aside on any of the ground at later stage, the party is bound to return or restore such cash money received, benefit received, or interest received through the other party from whom it is being received. Right? Is it clear? So it means section 64 doctrine of restitution is applicable in case of coercion. It will become an effect of coercion. And the last thing is that we say guilty may be liable to criminal action. So if he has done any activity which is against IPC, or any harm has been given to any person or property of another, then in that case criminal action can be taken separately. But when we talk about the Indian Contract Act, so it talks about the civil law. it talks about the law of the relations, it talks about the how it is to be performed. So in that particular situation, this civil law or rules of Indian contract will be applicable. But along with that, if any activity which it attracts criminal liability or offense, then in that case criminal action will also be taken. And lastly, the burden of proof. So in this case, the burden of proof lies on the party who wants to avoid the contract. Otherwise, if we will see in case of undue influence, the party who have used the undue influence is required to make the proof. But in case of burden of proof, the party who is going to set aside the contract is required to show the genuineness of the case that the consent of the party has been affected by coercion. So now, if you have any queries in case of coercion, we can discuss this. Or otherwise, I think we'll start the next topic tomorrow because it's going to take one complete class. But I won't be discussing the voidable contract meaning, or I will not be discussing the doctrine of restitution again. We will just be strict or discussing about the undue influence, will discussing the fraud and misrepresentation in coming classes, because these affects doctrine of restitution or setting aside of contract or meaning of voidable contract, everything remains same in the for the coming sections as well. So if you have any queries up till now, so we can discuss these queries. Otherwise, let's discuss